course, I just closed it. Oh, I just emailed it to you, didn't I?
Yes, I do have it. Do you prefer if I advance slides for you? Because I'm happy to do that.
I just pulled it up from the email I sent you, so I should
Okay.
be just a second.
Awesome.
Let's try that again. Okay, so you guys will have to tell me, you're seeing the screen with the notes, is that correct?
Yes, we see the notes version.
Okay, is that better?
Yes, that's perfect. Thank you.
Perfect. I don't have a lot of notes, but we will, that's better for you guys to look at. So before we really get started, I know we have a bunch of pharmacists joining us today, and we have a number of our CED PBS folks. So how many people, and you can just press the little raise your hand thing, or you can physically raise your hand, how many people have worked with clients who either themselves are maybe going through a CPS case, or the client's parents are going through a CPS case? Okay, so a number of people. And in your experience, do you know that any of the parents went through a parental fitness evaluation? Everybody knows. Awesome. Well, then I got a lot to teach you today. So let's kind of figure out, when does this get referred? What does this mean? What are we talking about here? So what is a parental fitness evaluation, and kind of why is it requested? So these cases are often initiated by CPS, or who in West Virginia is within the Department of Health and Human Resources. I would tell you which branch they are, but the legislature is currently going to make that a whole big mess, and it'll just confuse you. So Child Protective Services within the Department of Health and Human Resources, and they're requested when a parent is being questioned. Usually parents being questioned about future child abuse and neglect. So there's been a referral for child abuse or neglect, and it's been substantiated, and they're trying to get a better understanding of this parent's ability going forward to raise this child or these children in an environment where they will not be exposed to child abuse and neglect. And so, like most evaluations when it comes to families, the standard that we look at now is what is in the child's best interest. There was a period of time where we thought there was this tender mother doctrine, and we believed that, kids needed to live with their mom, and they needed to be with their mom in order for them to kind of build relationships, grow, and flourish. Well, we found that that wasn't necessarily the case. And then even before that, there was this belief that, men kind of ruled a household, and their wives, the wife and the children, were kind of the property of that man. So there was this belief that the man kind of owned the child. And so we've really kind of shifted on the pendulum at two different extremes, and have kind of settled somewhere in the middle, now recognizing that it's not really about either of the parents, it's about what's in the child's best interest. But specifically for these parental fitness evaluations, the question is it in the child's best interest that they reunify the parent with the child? And so some of the questions that we are asked by the courts is, what are the parent's mental health needs, and how do they impact the child? What intervention strategies might work best? What type of what effect would termination of parental rights have on this child? So I'm going to skip that real quick, and I want to talk about this page, and I'll go back. So when we talk about parental fitness evaluations, they often get confused by everybody, the difference between a parental fitness evaluation and a custody evaluation, including myself when I was first beginning these. As a trainee, I was always told, don't do a custody evaluation. They're really litigious. It'll be really awful. Just don't do them. And so I kind of held off on parental fitnesses for a long time, and kind of have given into these types of evaluations. So the big difference between these two is that in a custody evaluation, we have two parents or parental figures, And the role of the evaluator is to determine what level of custody, what amount of custody should each parent get. So almost which parent is better to serve the best interest of that child, or which parent maybe has the best resources or the most stability for that child in that situation. So custody is going to be between two people, and we're trying to see who's a little better for this child than the other person. The parental fitness evaluation is not a comparison between two parental figures. A parental fitness evaluation is simply, does this parent in front of us, who's been this evaluation has been requested for, does that person meet a minimum level of parenting, minimum bar? And it's a really low bar. In the United States, we have a constitutional right to parent our children. But we don't have a constitutional right for our children to experience abuse and neglect. And so, when it's forensic evaluations, it's always coming back to, because of a mental illness or a mental condition, does this parent meet a minimum level of parenting? Or are they below a minimum level of parenting? And if they are below a minimum level of parenting, can we bring them up to that minimum level, or should their parental rights be terminated? So another way to look at it, they're sometimes called parental capacity assessments or parental competency assessments. And this competence has been described as kind of the floor of acceptable parenting, sufficient to protect the safety and well-being of the child. This is as good of a definition as we have. The law has not clarified this any more specifically than minimum level adequate parenting. And it means that each evaluator and each CPS, MDT, and each judge and each guardian ad litem has to kind of figure out what acceptable parenting means to them. So I want to throw it back to the group right now. What does that phrase, either the phrase minimal parenting or acceptable parenting, what does that mean to you? What kind of comes to your mind when you think, okay, this would equal acceptable parenting, this does not equal acceptable parenting?
I guess my thoughts would be bare minimum resources. So they're clothed, they have a home, they're fed, they're clean. They're in school, seeing as that's the law. And I guess maintaining they're alive and healthy and safe, a safe environment. Okay.
So we have minimal kind of shelter and safety things that have to be in place, right? Clothes, food, water. And then on top of that, we have some they need to be fed, they need to be healthy, there needs to not be safety concerns in their environment. I like that. That's very kind of if we're saying they just need to be clothed, that's about as minimal as we get, right? And I think with these evaluations, can the parent make sure those things occur for the child? Does the parent understand that those things are necessary, that the child deserves to have those things? And can they implement them? Can they get those resources together? Yeah.
Anastasia also chatted in saying ability to keep child safe and minimally cared for.
Yeah, child safe, minimally cared for. Anastasia, do you care to elaborate on what minimally cared for might look like?
I was just putting in the just ability to keep them safe, and then I was just wanting to echo what someone else said about the, keeping them fed and clothed and taking them to school.
Yeah, it's interesting. The case I think that I want to talk about later had to do with schooling, and it was there's educational neglect is actually something you can be charged with within CPS, which I didn't quite realize before. Other thoughts? How many people are sitting there going, well, I don't know how to define that. I don't know what's acceptable parenting. Nobody wants to own up to it. Well, that's exactly what I think oftentimes. I don't know what acceptable parenting is. I know what I do as a parent, and who knows if that's good enough. I just, kids seem pretty happy to me. So the thing with the parental fitness evaluations, and the thing that I really talk to trainees about often, is that there is a lot of judgment in parenting. If you've ever been on social media and you've seen the post about, my goodness, this mother breastfed and this mother didn't breastfeed, and she's breastfeeding for too long or too short or didn't try, you can't win as a parent with social media these days. But it's also important to know that, some of them we can recognize as judgments, but a lot of the parenting stuff that we use, that I'll say I use as a parent, comes just from my belief system, my values, my cores. There are books out there that kind of help you, like, what should a parent do? What should your 1-year-old be doing? But really, we learn this through our parenting, like the families that we grew up in, the families that we've witnessed. And it can be really difficult when evaluating these families to not get stuck in a kind of judgment place. And the one place where I believe that I'm okay to be judgmental a bit is car seat safety. And that's the one place that I kind of educate parents when I see them about what is adequate car seat safety. And actually, in my last evaluation, had to educate a worker to educate other staff that what you're saying in your notes is not adequate car seat safety for a 4-year-old. But just keep in mind, there's a lot of judgment, and we have to we're always trying to be objective, but with these, I think we have to be extra careful that we're not judging. The other area that becomes really challenging with parental fitness evaluations is I'm always kind of aware of kind of poverty and the role that poverty is going to play in these types of cases. So a person's SES level of poverty should not be the reason that their children are taken out of their care. However, we know that with economic instability comes housing instability, comes food instability, and it starts to kind of all become these issues. And so I have addressed this and spoken with many CPS workers to see kind of where do they fall? How do they know, okay, this is an issue of SES and their socioeconomic status and their ability or inability to have a job, and that's okay versus that's not okay. And they talked about it being the willingness of the parent to seek out other resources. So are they applying for HUD? Are they following through when they don't hear back from HUD? Are they getting Medicaid? It's kind of them, if the parent is demonstrating that they are working to get all of the resources in place, then that would be a place where CPS is not trying to say, okay, you can't parent that child. But let's
Dr.
go.
Lillard. Oh, sorry.
No, go for it.
So Ashley Benson actually chatted in asking, why isn't there a checklist to determine a specific range of acceptable to take out the subjectivity?
That is a great question,
Yeah.
Ashley. And I will say it's really hard. There are some areas of forensic psychology where it is very clear, and it really depends on the courts. Because if the courts are going to lay out a statute or a standard, for example, competency to stand trial, the courts have said, the Supreme Court of the United States has said, competency to stand trial means you have a factual understanding, you have a rational understanding, and you can work with your lawyer. That's about as clear as we're going to get when we're involved in, this kind of intersection between mental health and the legal system. When it comes to parental fitness evaluations, the courts have not spoken up and provided a standard. And so if they're not going to stand up and make a statute or set precedent about what is acceptable parenting and what is not, then we as the evaluators are we do the best that we can. So you have a bunch of researchers and clinicians who are publishing papers on ways that we can kind of standardize this. So there are some standardized measures that we can use that are helpful. And there's this, I love this book series, but there's a book series called Best Practices in Forensic Mental Health. And it's a book for each type of evaluation you could do. And this one is all about parenting capacity assessments, and really helpful. It talks about like what records you might want to get, what risk factors, what protective factors. So there are ways that we are trying to standardize, but again, you know, we work kind of at the mercy of the court system when it comes to these cases, and if they haven't kind of set that standard. And some of that is that judges kind of, they get to set their own standard to some degree. And so we are to provide them with kind of the strengths and the weaknesses, provide them with the possible interventions, and then they kind of take it, they take it from there. But great question. Yes, being standardized would make all of this much easier. Then you probably wouldn't even need a forensic evaluator. You could just checklist it off. You know, the CPS worker, the MDT, the multidisciplinary team, they could be the ones that just kind of check the boxes off and say, okay, you're a fit parent or you're not. And so part of it is like, I've been looking for like questionnaires about parenting knowledge. Like, could there be a questionnaire out there that just says, ask the person a question of how often should you feed your child? I don't know. And they write in their answer and they get scored on that answer. And then you have another question, which is kind of how I finish up my evaluations. I've got a whole laundry list of areas that I talk about, and I want to know what they know about fire extinguishers and smoke detectors and carbon monoxide detectors, and what should you do if your child is choking or bleeding or fell, and you kind of go through these different scenarios with the person. But there's some forensic evaluators that they don't even do kind of those kind of questions in parental fitness. So the second part to Ashley's kind of question is that West Virginia has no standards for parental fitness evaluations. It's not written in code who can conduct them, how they should be conducted, who should pay for them. It's kind of the Wild West at the moment. And so it's been a learning experience to see kind of best practices of what they should look like. So a little bit of history behind parental fitness, parental capacity. And it kind of starts with the Latin phrases the court loves to use, which is parens patre. Somebody who speaks Latin, I apologize, because I'm sure I just butchered it. But this is the idea that the country acts as parents. And this is the concept behind juvenile justice as well. It's the idea that the court system is there to protect kids and youth and the vulnerable. And so the government or the court system has a strong interest in the care and nurture of children and people who can't function independently. So there's your intellectual disabilities, there's incapacitated adults, there's, you know, your older adults maybe with dementia or neurocognitive disorder. The government feels very strongly that they need to protect the vulnerable. And so because of that, that's why they believe it's the government's right to regulate abuse and neglect. In 1944, a case out of Massachusetts, Prince v. Massachusetts, said that parents don't have an absolute right to their children. Before this, parents were in charge. Whatever the parent wanted to do to the child was okay because parents had absolute rights. And so this case is when the courts finally stepped in and said, okay, we can restrict a parent's rights to their children. We're not going to do it in many cases. It's going to be very rare, but we can restrict parental rights if we can restrict them if the custody, care, and nurturance of the child reside first with the parents, whose primary function and freedom includes preparation for obligations the state can neither supply nor hinder. So the state's not trying to take care of all children and all families. And if the parents are functioning and they're preparing the child and they're caring for the child, then the state's going to leave them alone, but it's not absolute. Then we have a case in 1982, Santosky v. Kramer. And this was looking at the termination of parental rights and kind of the, it's called a burden of proof. So if you're looking at a criminal case and someone's been on trial for murder, the court, the prosecutors have to prove beyond a reasonable doubt that that person committed that crime. That means that we are like 95% certain that is the person who committed that crime. And we only find people guilty, we're only supposed to find people guilty in this country if that burden is met. However, there's other burdens for different situations. So some situations, It's just a preponderance of the evidence. And so that's more likely than not. Like I'm 50.1% sure that this person did it, not this person. And so when we're doing competency evaluations, my burden, or if you've heard physicians say, I make this opinion with reasonable degree of medical certainty, to many people, that is this preponderance of evidence. It's more likely than not that I'm correct in my opinion. And that used to be the standard to terminate rights. Well, the courts feel like more likely than not, the child's going to be re-abused, then we can terminate parental rights. And they said that's not quite high enough, that this is a right of parents and it should be held to a higher standard. So they changed it to clear and convincing evidence. And so that's somewhere in between that beyond a reasonable doubt and preponderance of evidence. In the middle, we've got at about 75%. We say I'm about 75% certain that if this child returns to this home, they're likely to be abused or neglected again. So when a judge is considering whether or not to terminate a parent's rights based upon all the evidence that's laid out in front of him, he's thinking, I'm about 75%. He's got to be over 75% certain that that leaving this child with these parents will result in continued abuse and neglect. And then Troxel v. Granville in 2000, that's the Supreme Court of the US, stated that parents have a constitutional right to rear their children as they see fit, as long as there's no abuse and neglect. This case kind of becomes important in West Virginia because this was a case about grandparents' rights. And so it was a case, two parents had divorced or maybe never had been married, and the father passed away. When father passed away, his parents wanted to see the grandchildren, and the mother of the children, who had custody of them and was not abuseful or neglectful, she wanted to move across the country. I don't know if they were in California or Oregon, and she wanted to move to like Virginia. And so the grandparents said, you can't do that. We have grandparents' rights to visitation with this kid. And the Supreme Court said, no, parents have a constitutional right to rear their children as they wish and where they wish, so long as they're not abuseful or neglectful. And so Amanda probably knows the stat right off her head, but how many kids in West Virginia are being raised by grandparents?
Are you asking me?
Or Lauren, somebody.
It's 28%, but I don't know the
3,000. There's 3,000 kids.
Okay,
that sounds right.
so about 3,000 kids in West Virginia are being raised by grandparents. Technically, grandparents don't automatically get rights to raising their kids, but you know, that would be if there's a parent that wants to raise their kid and it's not abusive, in an abuseful and neglectful situation. All right. So that's all the boring history. Quick overview of types of maltreatment. I think we probably all have heard this and know this. But the first being physical abuse, which is defined as a non-accidental physical injury to a child, including striking, kicking, burning, or biting. We have child neglect, which comes up pretty frequently as a reason for a CPS referral. That's deprivation of adequate food, clothing, shelter, or medical care, or just deprivation of, being in a safe environment that comes with that shelter. And then there's endangerment. That's placing a child in circumstances with individuals who could reasonably be expected to put a child in danger. If you know that person is actively using drugs with syringes, or there's needles all over the house, and you place your child in that situation, it's reasonably expected the child could be in danger. Emotional abuse, injury to the psychological capacity or emotional stability of the child as evidenced by an observable or substantial change in behavior, emotions, response, or cognition. That one can be, I think, more difficult for CPS to really demonstrate. And the last is sexual abuse, and that's defined by both the motivation and the specific areas touched and the degree of penetration. Sexual exploitation generally includes allowing children to engage in prostitution or involving them in the production of child pornography. When we're talking about parental fitness evaluations, we're usually not talking about sexual abuse cases, usually. And we're usually not talking about really serious physical abuse cases. Because in those cases, CPS often has enough medical or other evidence to say this person is not safe to be around children, and they can terminate parental rights for other reasons. The cases that I see when it comes to the termination of parental rights, they are cases where there's a mental health diagnosis going on. So it's often one of three areas. They have a severe mental illness, and their severe mental illness is impairing their ability to parent. But there's a concern that their severe mental illness will impair their ability to parent. The second is they're actively using substances, and their substance use is impairing their ability to parent. And third, they have an intellectual disability, and because of that, it's interfering with their ability to parent. So we're really looking at kind of where it intersects with mental illness, which can be difficult if we are given a case where it's not mental illness that potentially causes the child harm. It just may be that dad is abusive. It might not be that it's because dad has PTSD or dad has anxiety or depression. And so it's important for the evaluators to be thinking about what is the mental illness causing this incapacitation to parent.
And Mandy actually chatted in asking, what do you do in a situation when the parent can't read and therefore they have difficulty applying for and maintaining aid, transportation, and essentially everything, where otherwise the parent would be fit?
Yeah, so I think that's a good one, because I think that also comes up with just intellectual disabilities in general. And they're, if a person has a right to parent, which is what the Constitution says, then, but at what point is it that their intellectual disability precludes them from having that constitutional right? And I think it comes back to this idea of, can they use the resources around them, or are there enough supports in their life to keep that child safe? So, for example, when I've done evaluations of parents who may, they may meet criteria for an intellectual disability, and their adaptive functioning might be such that they need significant supports themselves, I'll say things like transportation is an area of improvement, because many of the parents that I see never had a driver's license, and it may be because of reading disabilities or issues. And so I may say things like transportation is an area of improvement. However, they now have a bus pass. They know the bus line. They know how to get from home to the grocery store, home to daycare, home to school, and back, and they're able to effectively use that transportation. Or yes, they don't have a driver's license, or they don't have a vehicle. However, their mother will transport them to all appointments. She has taken them to all the visitations. She takes them to all the doctor's visits and makes sure the kid gets to school. And so it's a question of, do they have the ability to use the resources that are available? And do they have enough supports to keep that child safe? And so I've worked on some cases where I've said, look, if this person is living independently in a house with her children, it is not safe. However, if she's living in an environment where there's another adult who is helping her care for those kids, or helping her care for her own kids herself, supporting her in that effort, then those accommodations probably are acceptable. And so when it comes to the reading level, I think it's more, what kind of supports can we put into place? Which is why in my evaluation, I'm talking about this parent's strengths, this parent's weaknesses, and then what interventions can we put in that would help those weaknesses. And then it's kind of up to the parent whether they're willing to accept the help, or use the resources in front of them. I hope that helps answer that question. So these are just some of the different needs. This comes out of that book that I was talking about before. And so A child's physical, cognitive, and emotional needs require this minimum adequate parenting in the following types of areas. So these are some examples. So when it comes to physical needs, there's a need for parenting that provides a physical safety, adequate supervision, protection from harm, stable and safe home environment, medical and dental care, and clothing. So exactly what Mandy was getting at the very beginning, right? Minimum adequate parenting is going to mean taking care of the child's physical needs. It also means taking care of the child's cognitive and developmental needs. So this need for parenting, this is the child has a need for parenting that is sensitive to their developmental level. So there may be people who, given the age of the children or given the developmental needs of the child, they don't have the resources and ability to care for that child safely. However, if it were another child in a different situation or a different age, it might be a different scenario. Do they have appropriate expectations about what that child can and cannot do? And this doesn't mean like, oh, they don't have appropriate expectations, let's terminate parental rights, but this is an area of improvement. So then, okay, if they don't have appropriate expectations, how do we change that? What resources, what parenting skills can we put, can we give them parenting classes that will help teach them these appropriate expectations? Can they communicate in a developmentally appropriate and clear manner? Can they impart knowledge and foster development and learning in different areas like language, self-care, school functioning, social skills? A minimum adequate parenting needs to include a child's emotional needs. So they need to be able to read the child's cues or moods without distortion. This one can be challenging. They need to show emotional affection and sensitivity. They need to use appropriate discipline to promote positive behaviors and growth. A parent that is empathetic and supportive. Again, these are all things, many of these, not all of them, many of these are things that we could teach if we implement the right services for a family. There's also factors to consider, which is a fit between what the child's needs and what the parent's caregiving capabilities include. So the specific developmental stage at which a child is and whether they have any special needs or delays. There was a recent case I was working on, and one of their children had cystic fibrosis, and the medical needs and the medical care that child needed were above and beyond the other children. And they had actually given guardianship to a family member of that child because they knew they couldn't meet the needs, the special needs of that child. But that didn't necessarily mean they couldn't meet the needs of another one of their children. And then being able to differentiate that is insightful. Parents' ability to not only meet the specific child's needs, but also the parent's ability to meet his or her own needs. This comes up a lot when you're talking about parents with their own trauma histories, their own mental health problems that maybe they're not treating or they're not adequately treating. Parents gotta meet, right? It's that what oxygen mask do you put on first on the airplane? You put yours on and then you put the child's on, because you can't help the child if you don't help yourself first. This is that same thing. You've got to meet your own needs first before you can meet the needs of your child. And then the role of factors such as culture, socioeconomic status, frequency of contact with the child, and interpersonal stressors on functional parenting skills.
And Dr. Lillard, Cheryl had asked, I think referring to the first bullet on the previous slide, asking how does corporal punishment play out with that? And Cheryl, please feel free to elaborate if you would like as well.
Yeah, so I think corporal punishment, it's interesting because I think it is a controversial subject. So I can't speak to CPS and whether corporal punishment would be a reason to substantiate child abuse. What I can say is we talk to parents about what kind of discipline they currently use, what kind of discipline they have used in the past. And we're looking more at, say corporal punishment is what they were using. Say the parent was using a belt to whoop a child. that may be something we put as areas of possible improvement and something to work on as, you know, appropriate discipline, developmental, what was the language that we used in the previous slide? You know, communicating in that developmentally appropriate and clear manner. So I think that it's less about what behaviors maybe have occurred, but how willing are they to kind of change their parenting going forward. But again, that doesn't speak to, I'm sure the CPS has in their regulations, you know, this type of punishment is acceptable, this is not acceptable. And the parents that I'm seeing for parental fitness evaluations, they have often had numerous CPS referrals, some of which were substantiated, and they may have gone through an improvement period and then they passed that improvement period and they were reunified with their children. And so it's not usually this event happened, you thought it was corporal, you thought it was punishment, we think it was abuse, we're going to look to terminate rights. It's usually this kind of long-standing, you know, you lost custody of your children for a period of time, you got them back within 3 months, you lost custody again, you got them back. Now we've lost custody again. Now this child is 4 and you haven't been the primary caregiver since she was 6 months old. That's kind of where these evaluations are coming into play. I'm gonna check our time. Okay, so some risk factors for parenting. We won't, oh, we got a new chat, didn't we? So we have a whole bunch of risk factors. Some of these I think are not going to be super surprising. They're kind of they're categorized into different types. So these are things about the child that raises the child's risk of experiencing abuse and neglect by a parent. So children who were born prematurely, low birth weight, kind of failure to thrive type children who have difficult temperament. So if you've got a child who's really kind of withdrawn or slow to warm up, or a child who's really irritable, that makes parenting a little bit more challenging, may raise their likelihood of experiencing abuse and neglect. Disabilities in a child, early separation from primary caregivers, negative peer influences, childhood trauma. Younger children are at greater risk for abuse and neglect when they can't protect themselves, they can't read any. Unfortunately, some children who have been in kind of long-standing abusive situations can kind of read the room. When dad starts drinking, I go to my room and I lock the door because I know that if I'm out there, it's going to be bad for me. And so, yeah, younger children much more at risk. Children if they have externalizing behavior problems, adds to that. And factors specific to sexual abuse risk. So female gender, lived without a biological father, stepfather, maternal employment. So I think they're saying like mom not working out of the home, older developmental disabilities. I'm not going to go through all these, but you know, best predictor of future behavior is past behavior. So prior reports of maltreatment, use of physical discipline, have different personality care. So these are about the parent, these are about the parent and the family, risk factors in parents and family. Pattern of abusive or neglectful behaviors, prior reports, use of physical discipline. So Cheryl, this is where your corporal punishment may come in. So the fact that they are using physical discipline raises the risk that it will get to a level of abuse and neglect. Again, that doesn't mean you use physical discipline, it is going to become abuse and neglect, but just raises, it's like a red flag. Keep in mind that when we're doing forensic evaluations, and these parental fitness ones included, we are not looking at just kind of one area or one thing, but we're looking at kind of lots of different data points that we put together to kind of make this picture. And so I think of risk factors as kind of red flags. So if I'm evaluating somebody and I know that there's this use of physical discipline, or they've had previous reports, substantiated cases of maltreatment, those are kind of red flags for me to pay a little closer attention. You know, if there are some personality characteristics, lack of empathy, chronic irritability, controlling tendencies, you can imagine that these are going to be people who are difficult to interview, and that kind of makes you take a look at whether that increases the likelihood of abusing and neglecting the children. Exposure to cumulative trauma, interpersonal trauma, so domestic violence, poor emotional control, violent outbursts, history of aggression and violence. So again, all kind of little flags that say, this isn't good, this isn't good, this isn't good. Well, you add all these up together and we have a problem. Other parenting factors, low frustration tolerance, emotion regulation difficulties. A lot of these can be treated with some of our evidence-based psychotherapy modalities. Social isolation, high levels of stress, substance abuse. The risk increases if it's both addiction and mental illness. So maybe a severe mental illness in addition to a substance use problem. In our morning talk, our CPS Echo that I attended this morning, they were talking that about 90% of the CPS cases have some form of substance abuse involved. Am I saying that correctly, Mitra? Was that your understanding?
That was my interpretation of as well.
So 90%. And so the cases that I'm seeing for parental fitness evaluations are the courts are considering terminating parental rights because this parent has relapsed again, or this parent is not yet in recovery. And so substance use is usually a huge component. And the court's kind of saying, someone help us. Tell us where the line is. We know that the substance use is a mental illness. It's a disease. They need treatment for it, but I can't force them to get treatment. And when do I know that it's safe enough for the kid to return home? Other discontinuous parental factors, some social and environmental factors, poverty, low socioeconomic status, large family size. When I think about the large family size, I think of, you know, a single mom or maybe a spouse that works shift work or works out of town, and there's 5 kids under the age of 5 in the house. You know, that adds to a lot of stress. Lack of access to resources and support, medical care, childcare, social services. Risk factors, unemployment, homelessness, just instability in housing. Exposure to race and discrimination, poor schools, dangerous and violent neighborhoods. The social acceptance of violence. I heard a lot about this in some really rural areas of West Virginia. And when you talk to people, there's just kind of this acceptance that, well, yeah, we fight. Yeah, parents fight in front of their kids. It's just kind of the way it is around here. And hazardous home environments. I think this comes with kind of a lack of knowledge about safety. And I think it comes with the kind of instability in housing. If you're really struggling to find a house and you find one, it's hard to be picky about what that house looks like, right? And if you're renting a house, you know, it might be a house that is from before the 1970s and has peeling paint. And there may be this concern for lead poisoning if the children eat the paint chips. Guns, weapons, fire hazards, and maybe it's a house that might have some electrical issues that the parent isn't going to know about. Or even if they knew about it, they don't have the funds to fix it, or the landlord won't fix it even though they're supposed to. So I think all of this kind of environmental factors can play a role too. But it's important to keep in mind that not only should we be talking about the risk factors,